Welcome to National Liberty Alliance's weekly call. Today is July 22nd, 2024. We broadcast live every Monday from 9 p.m. to 11 p.m. Eastern Time. If you're listening over Rumble or YouTube or another network and you would like to ask a question or make a comment, you can go to nationallibertyalliance.org and click on a weekly call for instructions to join us by phone, app, or browser. If anyone would like to email a question, you can send your questions to questions, as plural, at nationallibertyalliance.org. Please support our business partners. You can find their banners on the right-hand side of a website of which the proceeds go to support NLA's effort to save our republic. Also, please support NLA by donating $5 a month or more. Click on our donation tab on the top right side of our website. Okay, we're going to pick up on our scripture reading where we left off last week. We're in the first epistle of John, chapter 5, being read by Alexander Scorby.
Chapter 5. Whosoever believeth that Jesus is the Christ is born of God, and every one that loveth him that begat loveth him also that is begotten of him. By this we know that we love the children of God, when we love God and keep his commandments. For this is the love of God, that we keep his commandments. And his commandments are not grievous. For whatsoever is born of God overcometh the world. And this is the victory that overcometh the world, even our faith. Who is he that overcometh the world, but he that believeth that Jesus is the Son of God? This is he that came by water and blood, even Jesus Christ, not by water only, but by water and blood. And it is the Spirit that beareth witness, because the Spirit is truth. For there are three that bear record in heaven, the Father, the Word, and the Holy Ghost, and these three are one. And there are three that bear witness in earth, the Spirit, and the water, and the blood, and these three agree in one. If we receive the witness of men, the witness of God is greater. For this is the witness of God which he has testified of his Son. He that believeth on the Son of God hath the witness in himself. He that believeth not God hath made him a liar, because he believeth not the record that God gave of his Son. And this is the record, that God hath given to us eternal life, and this life is in his Son. He that hath the Son hath life, and he that hath not the Son of God hath not life. These things have I written unto you that believe on the name of the Son of God, that ye may know that ye have eternal life, and that ye may believe on the name of the Son of God. And this is the confidence that we have in him, that if we ask anything according to his will, he heareth us. And if we know that he heareth us whatsoever we ask, we know that we have the petitions that we desire of him. If any man see his brother sin a sin, which is not unto death, he shall ask, and he shall give him life. For them that sin not unto death, there is a sin unto death. I do not say that he shall pray for it. All unrighteousness is sin, and there is a sin not unto death. We know that whosoever is born of God sinneth not, but he that is begotten of God keepeth himself, and that wicked one toucheth him not. And we know that we are of God, and the whole world lieth in wickedness. And we know that the Son of God is come, and hath given us an understanding, that we may know him that is true, and we are in him that is true, even in his Son Jesus Christ. This is the true God and eternal life. Little children, keep yourselves from idols. Amen. The end of the first epistle general of John.
Okay, Jan, do we have any questions tonight? Or any announcements?
Yes, we do. The first one's a long one about tactical civics. Are you familiar with tactical civics and all its innuendos?
Yeah, what were you saying now? It's about tactical civics. I think, I don't think that they work with anyone. They're loners, aren't they? Isn't that the group? Yeah, I believe that's the group. I don't know if someone could correct me on this.
That's correct.
Yes.
GR knows about it. He knows the guy that's at the head of it, and in their charter, they cannot work with others. So there you go.
So that makes them, not compatible with us. We're working with as many groups as we potentially can, providing, of course, we're reasonably compatible, particularly on the law. But next question, I guess.
Okay. The next question has popped up a number of times and does not have a solution yet. We only have certificates listed for the Civics and Constitution course in the store. Now, this person would like to pay $25 for a certificate of finishing or completion of taking the Grand Jury Administrative Accredited course. How do you go about getting this certificate?
All right, well, I haven't had time to get involved with that and putting something together. I'll try to do something soon, but right now I'm just way too busy on reading and researching and writing and preparing for a lot of things. Time is short. We have a lot of work to do, a lot to accomplish before the end of this year, and but we will eventually get to that. It's not a necessity right now, but anybody that is looking to become an administrator for the juries, both trial and grand juries, they're going to be required to take all those courses and have those certificates, particularly the one for the administrator. But till further notice, we'll do something as soon as we can, and once we do, we'll make an announcement of its availability. Okay, next.
Okay. This person wants to know, would it be possible for you to interview Rick Martin from the Constitutional Law Group?
Well, if this person has a contact information with that person, they could maybe connect us, and maybe we can have a meeting with that individual and have a conversation and see once what we might do. Generally speaking, we don't interview people. We're looking for interviews. But there are occasions. I mean, we did have a conversation with Sheriff Darr, but generally we don't do it. But again, make the connection. We'll have a meeting, conversation, see if we can't work together. Next.
Okay. I am working on your GBC course. Nowhere in it, so far, do I see anything about the U.S. and D.C. being a corporation. It is plain to see in USC Title 28, Section 3002, in Parents 15, A, B, and C, where A, the United States means a federal corporation, B, an agency, department, commission, board, or other entity of the United States, or C, an instrumentality of the United States. It's my understanding that this was brought in through the unlawful creation of another government with another constitution in 1871. Is this included with teachings at NLA anywhere?
Well, of course. If you take our civics course, you'll learn a lot about that. There's a lot of information in all of our courses, or a good deal of our courses anyway. But specifically in the civics course, we deal with a lot of that. There is no need to put it in a course that is teaching law for the purpose of due process. It has nothing to do with due process. That whole system and organization and all of that is a fraud and has nothing to do with due process, so it wouldn't have been taught there. But yeah, we do have plenty of information on that. Go into our educational tab and start looking around on different things. You can read on different things. We've got memorandums. Matter of fact, I just put up a new page called Memorandums of Law. I thought we already had this up there. We do have a lot of memorandums of law on our course, but I wanted to put a lot out there. I thought it was already, so I created this page. It's underneath Education Starts Here. And you'll find some information on this. For instance, the abrogation of the law of the land would deal with this kind of a situation, the abrogation of the United States, and there's some others. And again, there's lots of videos. If you go to our Rumble videos, and I think we still have we do have a YouTube video still up, but we don't get many hits on that. But I think we have an old YouTube that might still be around. But we did move all of our videos over to Rumble, so if you go way back in Rumble, you see a lot of information on that kind of stuff, a lot of subversion, a lot of things going on. So we do cover a lot of that. We talk about that, but we don't teach people to do anything like, to get rid of their driver's license or social security number, or try to become a nationalist, or any of those things, because that's just running away from the problem. It doesn't solve the problem. Nobody should be giving up their citizenship, because if they did, you'd be at risk of being deported if you're not a citizen here. And the other thing, of course, being a citizen, there's nothing wrong with that. They have made it a dirty word in a sense. I usually try, when I go into courts, I always say, refer to us as the people, or one of the people, particularly of New York, instead of using the word citizen. But we shouldn't have to run away from that. Citizen is used 7 times in the Constitution. I am a citizen of the United States. Anybody who comes into this nation, we've given Congress the authority to, create the citizen, to make someone a citizen. So they have to become a citizen of the United States in order to go to a state where they want to live and become a citizen of that state. But ultimately, we're citizens of all the states. We have all the powers, all the authorities, everything that is in any other state. So, all right, next question.
Someone had sent me that same question either this week or last week, and I just searched it on the website, and in Chapter 3 of the Civics course it says, in 1871, the 41st Congress acted without constitutional authority, an act of fraud. The Organic Act of 1871, conspiracy and subversion against the USA. Da-da-da-da-da. Therefore, all later construction upon the Organic Act of 1871 is as null and void as the act itself was never. Da-da-da-da-da-da. So it's all there in Chapter 3, John.
Chapter 3. All right, and again, we did basically address it, but we didn't get into a lot of detail in that because, again, it has nothing to do with the law, but it does, we did, of course, expose it. There is a memorandums in here. One of the memorandums, or a couple of memorandums, probably deal a little bit with that subject matter. It's sort of information for people if they want to use it in a court case. But again, we go into the courts from the position of that's our courts. Now, they may have stolen it from us. They may have the guns, and they may have taken it from us, and they may control it. They may kick us out. They may prevent us from coming in. It still doesn't take away from the fact that those courts belong to us and that they are the aliens, not us. That day of reckoning is coming. Our purpose in the courts, as much as we would like to win the cases we filed, which is far and in between, generally speaking, the purpose of our cases mostly is to prove the subversion against the United States of America by the way they act and respond to all of the different, court cases that we have filed on behalf of others and on behalf of everyone, actually. Matter of fact, we're going to be talking about that tonight. More court cases coming up that we're going to be filing. But anyway, next question.
Okay, this is a quick one. Please advise if NLA is accepting move for cause to federal court joiners or not accepting at this time.
Well, we are accepting affidavits, and if you have a court case, matter of fact, let me see where I found that. We have a website that's supposed to be launching, but there's been a few problems, and I'm waiting for the person to get back to me in order to put that together. But we do have, let's see, I'm trying to think where I put it. I think I put it under here. Stuck in an abusive court. You'll also find it on the right-hand side of our website. You'll see a icon with that crazy judge there. But basically, I'll just read this very quickly. There's not much to read. I'm not going to get into the long paragraph, but just the beginning. Natural law requires that for every injury there must be a remedy. If you have been injured by the courts, we, the Unified United States Common Law Grand Jury, will restore you. Examples of injuries: mortgage foreclosures, tax foreclosures, denial of due process, unlawful imprisonment, denial of habeas corpus, denial of your right to travel, hijacked into a family court, hijacked into a probate court, denial of any other unalienable right. I'm not going to read the rest. People can go out here and read this. If you do decide, we do have a link here where you would then set up your affidavit. We do require to follow the plan that we have. So here's a copy. I did it in Microsoft Word. I don't know if it's necessary to do it in PDF. If someone requests it, we'll put it up there if they can't get Microsoft Word for some reason. But generally speaking, at the top of this affidavit, you do want to put in, and you don't want to get too wordy. You want to focus in just specifically on the details of the facts. We don't want any cases attached to it, but if you do have a case that you're in or a case that you've lost, whatever the case may be, then you can put that information on the top. For instance, it says if there is a court case, do not attach. Just fill in the following: case number, court name of the judge, and the address of the court. That's all we need. The rest, of course, is the affidavit, which is the important thing. All of these affidavits will be attached to our final paper, which we're going to talk a little bit about tonight. Next question.
You probably recall from last week that we had a question about did you have to file a notice of intent to sue. There is a revision to that question tonight, and it seems to read the same almost. What I meant to say is, must I write a notice of intent to sue a government agency?
I never have. I never will. It doesn't. Look, I try to follow their procedures as much as I can. Anything that is lawful, anything that is in harmony with common law, I'll follow along. I'll use their codes and their statutes and regulations to control them. They have nothing to do with me. They can't write a statute requiring me to do anything in my court. Of course, it's the king of the court is the king's court. But generally speaking, I'm one of the sovereign, one of the people, one of the kings of the King of Kings. And that court is mine. It's not theirs. It really disturbed me when I was watching that one judge who was making all these rulings over Trump, and then there was a case where a lawyer wanted to come in and speak, and I forget exactly what was going on with that, but they wanted to get more seats in the courtroom because there was a lot of other lawyers that wanted to come into that case and listen in, and they said there was no more room in the court. And the lawyer for the other lawyer said, well, you got the bench over here, the juror's bench. You got seats there. We can put them there. And the judge, whipped back out at the guy. There ain't nobody sitting in my jury box. Well, it's not his jury box. That's our jury box. He works for us. But that's the attitude they have. I don't participate with it. I make my point and I move on. We've sued a lot of people. They throw us out on a lot of things. I've never been thrown out on that one. Not to say we wouldn't be, because that's just another piece of their ammunition. But anyway, next question.
That's all, John. There are no more tonight.
All righty. Okay. Generally speaking, well, let's see what we're going to be doing here. We're going to be filing a series of presentments for declaratory judgments in the Supreme Court. I'm researching right now to see if we can go directly to the Supreme Court. I think we can. I've heard about that. Someone has sent me some information on that. I haven't had time to look at that yet to see what their perspective is. And I'm talking to others and I'm researching. The type of cases we have going, I don't think the lower courts could answer anyway. They'll probably say it's moot. And that brings us to, well, okay, if it's moot, we're going to challenge it. Let's talk about it. We're going to try to settle it. And the only way we're going to settle that is to take it to the United States Supreme Court. So, again, if we can move directly into the United States Supreme Court, our cases will run a lot quicker. If we can't, then it's going to go through a process. We've got to throw it into the trial court. It's going to take at least 45 days to go through that process. And by the time, and the quickest we'll be able to respond, unless they kick us out early, then we'd go for the appeal, and that could take a couple of months. And then at that point, we go to the United States Supreme Court. And that's what I mean. The time is running out. We have papers to file. They need to be filed before. And we'd like to file one a week. There's about 6, well, actually, I'm looking at about 9 of them. I'm going to go through them very quickly, and we're going to talk about one tonight particularly. But we want to file them. I'm going to file them one after another. But that depends on the people. That depends on people supporting this, because it's going to get quite expensive going into the Supreme Court, which we'll talk about that a little later on what kind of cost it's going to be. But we do have some very powerful and important cases. We need to get into the courts. I had certain ideas about what we were going to file, what we were going to do at the end, but I came up with some other thoughts and ideas as time went on, and I realized we can't hit up on 10 different items in one case. It's just too much, and everything, and many things will get lost. So it's like coming in one shot at a time. Make the point, look for a decision, make the next point, look for a decision. And again, we're going to do this back to back to back, if it's possible. I've got the papers pretty much written, or at least some of them. All of them, I could get them pretty much completed probably in a week, because a lot of the necessary information is already written. I just got to kind of put it together and put in whatever I need to put in for that particular point, which again, we'll talk to those details in a few seconds. So anyway, we are looking for people to get involved and really start helping to push this forward. And if we don't push it forward, then the people spoke. They're not interested in getting their courts of justice back. I can assure you, there is nobody working on what we are working on. There is nobody doing all the things that we are doing. There's nobody doing almost everything we're doing. We're doing so much. We're working with building committees of safety. No one is doing that. We're working to teach people a real, a proper education, as Jefferson spoke about. We worked and put together proper educations. We're working to take our schools back. We're working to bring a proper curriculum into the schools, even writing books for the sole purpose for the children to truly learn who the founders of this country is, what the common law is, how to work their way into the courts, how to take care of their own lawful business, and teaching children that they have to give back because and they have to get back. What was that?
Okay, you didn't say anything, so I didn't know if you could hear me or not. All right.
I'm talking. Nobody's hearing me.
Oh, okay. Well, you got to say something.
Oh,
I know that I can.
Terry, you got to be muted here. All right. I lost my train of thought where I was. Let me think. Well, let me just move on to the next step. I don't know if anybody wants to remind me what I was talking about. What we're trying to do is bring these cases into the courts. Okay, the first step is we want to restore our sheriffs across America. I didn't realize how bad it is. There are 21 states with major problems concerning their sheriffs, and there are 20 counties particularly that have serious problems in them. Of those 27 states, when you put it all together, they've been working to really destroy our sheriffs for a very long time. Psychologically, they've already done that in Hollywood. They make the sheriff look like the water boy. And they've taken his authority away in so many places. So this is a serious problem. So working with others down in Virginia, this is the first case we want to push through, which we're going to look at tonight. Another case we need to work on, and we'd like to get this in. Again, I'd like to do this every Monday, file a case every Monday until all 9 of these are filed. And at least at that point, we have a chance of getting all of these cases heard by the time we get to the end of the year, which is really our target in order to bring our court systems back into courts of justice, to define them very clearly, what a court of justice is, what a court of record is, and all of the different things, and how powerful and the necessity of a sheriff. Okay, the third case is, and again, this may not be in this order. I have to think about the order to set these in. But another case is restoring the concealed original 13th Amendment. And that goes back to 1819, or 1819, I think, is when it was finally became law. Also restore the balance of power. The 17th Amendment, major problem. That's what gave them the ability to take this nation over. They had to get rid of the senators. They had to bring it to popular election because they already control the people to some degree. Psychologically speaking, they also control the ballot boxes by stealing and so on and so forth. But the 17th Amendment is extremely important, which took the power and the authority of the states. The states have no say what goes on in Washington, none whatsoever. Okay, also restore right to practice law, restore free access to court, deal with the null and void Engel versus Vitale, which is the Bible in the School, taken out in 1963. The right of the people to call and orientate the grand and petit juries. That's what we're working on by building administrations of for the jury. And then the final one is a presentment to the Supreme Court with an indictment against the judiciary, the entire judiciary. They all got to go. We also have to deal with the bar. I didn't put that one in there, and there may be some others. So again, there's a lot of work to be done. Again, I can get one paper out a week very easily because I've done so much work on all of these areas. But tonight's subject, we're going to focus in particularly on restoring our sheriffs. And hopefully we'll have some conversation after that and maybe some questions. I would ask tonight for any questions that come up to really keep them focused on the subject matter tonight. And we're going to try to pick up all of these different subject matters over the course of the next couple of months, laying these things out. Actually, and hopefully, well, what I may have to do is I may have to get ahead of the game and kind of do some recording of some of these things to put them up onto the internet in a quicker fashion, because to get 10 cases out, let's say, would take, 2.5 months? Although we would get them out a lot quicker, hopefully, if we get the funding, we'd get them filed. But at least we want to get them up on the internet and read them, at least the important parts of the case. Okay, so what I want to do tonight is take a look at this case. It's written, it's ready to go. I hope to file it this week. And again, a lot of it depends on the people. We do have someone who is pretty much offering to fund this particular one and pay for the cost of this one. Hopefully they'll be able to come up with enough money to deal with it. We don't have lawyers. We don't pay lawyers. All of our writing is done for free. So we don't have to pay lawyer fees. No one's getting rich off this. It's just a bare, hard cost. That's it. Okay. So again, this is, right now I got it set up as being filed in the United States District Court for the Northern District of New York, and that may change because if we can go straight to the Supreme Court, that's where we're going. I think we can do that, and we'll find that out soon. Okay, so this paper is being written by the Unified United States Common Law Grand Jury, which are the plaintiffs. The jurisdiction is a court of record, and we've got to get a federal case number. And it's against a number of people, Chief Judge James Lewis, ETAL, et al. Okay, he's the only individual going after directly, and we're going to read a little bit about that, and you'll find out why. But everyone else, really, we're going after legislators and counties. Okay, so we've listed them out. This is a grand jury presentment for a declaration and order to guarantee a Republican form of government. And I'll start reading and begin. Comes now the constituted Unified United States Common Law Grand Jury of the 50 United States of America, hereinafter we the people, in this court of record for a declaratory relief against, and then we list out all of the individuals. I'm not going to read them all. I will post this paper up, probably in a memorandum area maybe, I don't know. But I'll find a place, I'll post it up, and I'll let everyone know where we post it. I'm not going to post it up until we actually get the final one. This is a draft. This hopefully is the final draft, but when we're ready to file, that's when I'm going to post it. But let me read on. Let's see. Let me go back a little bit. After I name all of the defendants, hereinafter defendants, for a declaration of a right that states are to guarantee a Republican form of government under Article 4, Section 4, that requires a county law enforcement officer. In in every county. Well, that's not the county. What is it? The chief law enforcement officer in every county, whose supreme duty is to uphold and protect the supreme law of the land, codified by we the people under Article 6, which is the Constitution, of course, without which there is no law enforcement, and therefore a lawless county, because absolute power corrupts absolutely. We the people demand that defendants guarantee a Republican form of government by restoring the power and the authority to our county sheriff that the common law requires in order to guarantee a Republican form of government, whereas defendants have blocked the election of, diminished, or entirely removed the powers of the people's chief law enforcer officer of the county within their respective states or counties, whereas defendants have put every person in the United States in jeopardy, for a cancer left untreated will eventually spread throughout the whole body. Jurisdiction. The Federal Declaratory Judgment Act 28 U.S.C. subsection 2201A states, in a case of actual controversy within its jurisdiction, any court of the United States, upon the filing of an appropriate pleading, may declare the rights and other legal relations of any interested party seeking such declaration, whether or not further relief is or could be sought. Any such declaration shall have the force and effect of a final judgment or decree, and shall be reviewable as such. If we can get to the United States Supreme Court, that's final. The federal courts is both subject matter jurisdiction and personam jurisdiction, having judicial power in all cases in law arising under the Constitution via Article 3, subsection 2, whereas this is a dispute concerning serious constitutional violations, whereby defendants violated their duty to guarantee to the people of their respective states a Republican form of government, whereas the federal district court is to guarantee a Republican form of government in every state of this union via Article 4, subsection 4. Defendants violated their duty to conform to the law of the land via Article 6, Clause 2, which states that this Constitution shall be the supreme law of the land, and the judges in every state shall be bound thereby. Anything in the Constitution or the laws of any state to the contrary notwithstanding. Whereas in order to establish justice, ensure domestic tranquility, promote for the general welfare, and to secure the blessings of liberty within each county of their respective states by requiring an election of a chief law enforcement officer, the sheriff, the only conservator of the peace, without which there is no peace. The sheriff is an officer of great antiquity, dignity, trust, and authority that the common law demands, and must be elected by the people and answer to the people and not the government. All other law enforcers throughout the United States are code enforcement forces that answer to a human political authority and not the laws of nature and of nature's God. The free and independent sheriff, the protector and enforcer of our founding documents, is the fail-safe of our common law republic, without which domestic tranquility and blessings of liberty is in jeopardy. As President George Washington said, government is not reason. It is not eloquence. It is force. And a force, like fire, is a dangerous servant and a fearful master. Historical background of the county sheriff and the sheriff's role as CLEO today. The Declaration of Independence is the foundation of American law, ordained and established by we the people and blessed by God, where we said that we were entitled to be under the laws of nature and nature's God. And we additionally said, we hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness, that to secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed. And that's what we teach people, how to have government by consent. If you don't know how, you need to learn. Everybody needs to participate. That whenever any form of government becomes destructive of these ends, it is the right of the people to alter or to abolish it, and to institute new government, laying its foundation on such principles and organizing its powers in such form as to them shall be seen most likely to affect their safety and happiness. County, state, or federal governments cannot write statutes that would alter that which we the people ordained. This founding document is a covenant with our Creator, who said, "Blessed is the nation whose God is the Lord," Psalms 33:12, making the United States of America the second natural law republic, ancient Israel being the first, established in 1400 BC. As Samuel Adams said, "The natural liberty of man is to be free from any superior power on earth, and not to be under the will or legislative authority of man, but only to have the law of nature for his rule." We read in 16 American Jurisprudence, 2nd edition, subsection 114, "As to the construction with reference to the common law, an important canon of construction is that constitutions must be construed to reference to the common law. The common law so permitted destruction of the abatement of nuisance by summary proceedings, and it was never supposed that a constitutional provision was intended to interfere with this established principle. And although there is no common law of the United States in the sense of a national customary law, such as comity, C-O-M-I-T-Y, and that, of course, is rulings by trial judges who just have come up with all these crazy rulings, and they claim that's common law. As distinguished from the common law, that's the natural law of the Bible, of England, founded upon the Magna Carta, adopted into several states, in interpreting the federal Constitution, recourse may still be had to the aid of the common law of England. It has been said that without reference to the common law, the language of the federal Constitution could not be understood. Whereas the bar, being in violation of 18 U.S.C. subsection 2385, deceitfully teach attorneys that common law is a compromise of judicial precedents, also known as judge-made law or case law, which is the body of law created by judges and similar quasi-judicial tribunals by virtue of being stated in with written opinions, claiming that stare decisis supports that defective thinking. Such conclusions violate the common law maxim. A thing similar is not necessarily the same thing. Lawyers and judges are to be guided by the principles of American jurisprudence that rest on authoritative decisions, being the United States Supreme Court, the Supreme Court, and state Supreme Courts, known by other names in some states, not trial courts. Stare decisis, contrary to what they have been taught, does not include comity. Moreover, when it comes to unalienable rights, such authoritative decisions by the Supreme Courts and legislators and legislation are sometimes repugnant to the law of the land and are thereby null and void. See Marbury versus Madison and Miranda versus Arizona. And when we, the people, challenge such legislation or authoritative decision, it must be heard for reconsideration. For example, the intent of Amendment 16, which the United States Supreme Court in Bush-Barber versus Union Pacific Railroad Company did see the encroachment and rightly and authoritatively decided that it created no new power of taxation and that it did not change the constitutional limitation which forbids any direct taxation of individuals. Another example yet to be corrected is Amendment 17, that destroyed the balance of power by removing state representation that was codified and ordained by we the people in Article 5, where we ordained that no state without its consent shall be deprived of its equal suffrage in the Senate. Whereas Amendment 17 clearly deprives the states equal suffrage in the Senate, thereby destroying the balance of power intended by we the people. This is an issue to be addressed for another time soon. The sheriff is the chief executive and administrative officer of the county, being chosen by popular election. Without a CEO, there would be no orchestration of law and order. There would be chaos. The Constitution and its capstone Bill of Rights are common law documents and cannot defend itself. It requires a common law officer to secure and enforce it. Common law cannot exist without a fully informed and fully empowered sheriff. The sheriff is an integral and essential element of the common law. Without the CEO, there would be lawlessness. All other law enforcement agents agencies are code enforcement officers and answer to government agencies and are sadly clueless to the unalienable rights of the people. And each of these agencies would be fighting for jurisdiction over its victim unless the CEO enforces the law of the land and puts an end to the abuse and chaos, thereby upholding the peace, being the chief conservator of the peace within his territorial jurisdiction. We are a nation governed by the common laws of God, which make our law superior and more just than any other nation's law. Therefore, the oath of the county sheriff is a sacred oath, which, when violated, is direct assault upon God, whose judgment will not rest forever. Thomas Jefferson professed America's covenant between God and we the people when he penned the following: when in the course of human events it becomes necessary for one people to dissolve the political bands which have connected them with another, and to assume among the powers of the earth the separate and equal stations to which the laws of nature and of nature's God entitles them, a decent respect to the opinions of mankind requires that they should declare the cause which impel them to the separation. We hold these truths to be self-evident, that all men are created equal. They are endowed by their Creator with certain unalienable rights, that among them is life, liberty, and the pursuit of happiness, that to secure these rights, governments are instituted among men, deriving their just power from the consent of the governed. Justice Scalia, writing for the majority in 1997 decision, said, "The sheriff is the chief law enforcer of the county," and also proclaimed that the states retained an inviolable sovereignty. Scalia went even further in his landmark decision, one in which two small-town sheriffs headed the feds off at the pass and sent them on their way. Scalia, in his infinite obligation to the Constitution, took this entire ruling to the 10th power when he said, "The Constitution protects us from our own best intentions, so that we may resist the temptation to concentrate power in one location as an expedient solution to the crisis of the day." Obviously, the sheriff is the people's last line of defense against a government or a government agent gone rogue. If it wasn't for sheriff in the said 1997 case, the feds, relying on judicial precedent, would have trampled on the law, and many would have been injured in the state and every other state. The duty of the county sheriff. The sheriff's principal duties are in the aid of the courts of record, not courts not of record, such as serving process, summoning juries, executing judgments, holding judicial sales, and the like. A portion of the sheriff's office carries out civil process at the direction of the court, such as eviction or process service of some legal documents. Courts of record proceed according to the course of common law, and without a sheriff there is no other law enforcer. Sheriffs are to preserve the peace, apprehend felons, and execute due process of law. The sheriff shall keep and preserve the peace within his county, for which purposes he is empowered to call to his aid such persons or power of his county as he may deem necessary. He must pursue and apprehend all felons and must execute all writs, warrants, and other processes from any court of record. Remember, court of record is the will of the people. It's the juries. They make the decision. Their word is final. And that's what he carries out. Well, he does carry out judges' orders also in equity when it's upon an individual that is required to be under equity, in other words, legislative authorities. Okay, so process of any court of record or magistrate which shall be directed to him by legal authority. Sheriffs still enlist the aid of citizens. The National Neighborhood Watch program, sponsored by the National Sheriff's Association, allowed citizens and law enforcement officials to cooperate in keeping communities safe. This is why the new mission of the Indiana Sheriff's Association and their slogan is building communities of trust in all 92 Indiana counties. As the sheriff law enforcement duties become more extensive and complex, new career opportunities exist for people with specialized skills. Underwater, diving, piloting boats, skiing, radar technology, communications, computer technology, account and emergency medicine, and foreign languages, especially Spanish, French, and Vietnamese. Sheriffs have a duty to provide law enforcement officers who are the sheriff's deputies, often called bailiffs in the court, which means guardians or stewards in our courts of record. Like the sheriff, deputies are to have a proper education. That's something we need to really focus in on. We have a plan for that, but again, it takes the people's involvement to make this work. You know, a small group or a handful of people can't make this work. It's up to everyone here to support the work that we're doing. You first need to believe in it, and when read these things, you should follow suit with us. Anyway, it is the duty of the sheriff to make sure that his deputies have a proper education. Bailiffs are not in the courtroom as a private bodyguard for the judge. He is there to protect the people, and the judge, who is also one of the people. He is there to keep the peace by making sure the law of the land is being adhered to, and that unalienable rights are not being violated. The sheriff's primary duty is to protect the sovereign, and of course that's the people, and ensure justice. They are responsible for maintaining the safety and the security of the court. A bailiff is required to attend all court sessions, to take charge of juries whenever they are outside of the courtroom, to serve the court papers, to extradite the prisoners, and to perform other court-related functions. Sheriffs are responsible for serving lawful warrants. Amendment 4, the right of the people to be secured in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue, but upon probable cause, supported by oath or affirmation, and particularly describe the place to be searched and the person or thing to be seized. According to the Black's Law Dictionary, the word oath, in its broadest sense, includes all forms of attestation by which a party signifies that he is bound in conscience by a solemn and formal declaration or assertion that an affidavit is true. No warrant, including a federal warrant, is to be served without going through the sheriff's office. Any warrant without a sworn affidavit and a judge's wet ink signature, not a stamp, is not an executable warrant. It is the sheriff's duty to make sure that all warrants, federal or state, served within their county pass constitutional scrutiny. IRS warrants rarely, if ever, pass constitutional scrutiny. For example, the IRS has a Form 4490 called Proof of Claim for Internal Revenue Taxes, which is the affidavit form that must be filled out and sworn to, without which the warrant with the wet ink signature cannot be lawfully executed. Sheriffs are responsible for maintaining and operating the county jail or other detention centers, community correctional facilities such as work release and halfway houses. Sheriffs are responsible for supervising inmates, protecting their rights, and providing food, clothing, exercise, recreation, and medical services. Before the sheriff is to accept any prisoner, he is to make sure that due process has been exercised. Unfortunately, because of the systemic ignorance of the law, county jails are filled with prisoners that have not received their right of due process. Black's Law defines an infamous crime as a crime punishable by imprisonment. Amendment 5 provides that no person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or an indictment of a grand jury. And Amendment 6 provides that in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury. The sheriff cannot accept any prisoner that were tried in courts, not of record, that cannot provide due process because they act without an indictment and are nisi prius courts. In other words, you've agreed to it before they can do anything. Generally, anybody working in commercial activities and working for government agencies, they've agreed to these things. We, the people, never will. Let me see where I'm at. Not having the power to fine or incarcerate. Let me go back and read that. Sheriffs cannot accept any prisoner that were tried in courts not of record that cannot provide due process because they act without an indictment and are nisi prius courts, not having the power to fine or incarcerate. Did you hear that? They don't have the power to fine or incarcerate. Town courts, village courts, and what else? City courts. At least most city courts. Some city courts are courts of record. You'll find that in your Constitution. Okay, So they don't have the power to fine or imprison, and in which the proceedings are not enrolled or reported. Law enforcement. A sheriff always has the power to make arrest with, and there are places where sheriffs can't make arrest. That's how bad it is. I discovered this in my recent research. Many sheriff, let me go back. Sheriff always has the power to make arrests within his or her county. Some states extend this authority to adjacent counties or to the entire state. Many sheriff's offices also perform routine patrol functions, such as traffic control, accident investigations, and transportation of prisoners. Larger departments may perform criminal investigations, and some, usually large sheriff's offices, command an air patrol, a mounted patrol, or marine patrol. Blackstone confirms the common law power of the sheriff to make arrest without warrant for felonies and for breach of peace committed in his presence. Blackstone Commentaries on the Common Law, Volume 4 at 289. Indeed, such powers are so widely known and so universally recognized that it is hardly necessary to cite authority for the proposition. General allegations. There is a covert anti-common law plot by enemies domestic, nibbling away at the office of the sheriff to diminish his powers, and eventually the sheriff removed altogether, like some states already have. Defendants, via ignorance of the law, or willing participants to destroy our republic, are denying the people's unalienable rights to a republican form of government. In a systematic and continuous course of conduct to remove the people's last line of defense against tyrants or tyrannical rogue states. Sheriffs are elected and recognized as fully empowered CLEO, in other words, Chief Law Enforcement Officer, in the following 23 states. So in these places they are recognized fully informed: Alabama, Arizona, Arkansas, California, I'm surprised California, Georgia, Idaho, Illinois, Iowa, Maine, Minnesota, Mississippi, Missouri, New Hampshire, North Dakota, Ohio, Oklahoma, Oregon, South Carolina, Texas, Utah, Vermont, Wisconsin, and Wyoming. Whereas the following 27 states, sheriffs have limited power or no elected sheriffs in some or all of the counties, or empowering the sheriff with unlawful powers such as enforcing civil law upon the people. They are Kansas, New York, Alaska, Connecticut, Delaware, Hawaii, Rhode Island, Pennsylvania, Colorado, Florida, Indiana, Kentucky, Louisiana, Maryland, Massachusetts, Michigan, Montana, Nebraska, Nevada, New Jersey, New Mexico, North Carolina, South Dakota, Tennessee, Virginia, Washington, and West Virginia. Police are empowered by men via legislation. Sheriffs are empowered by God via natural law itself. Every citizen has a personal stake in the outcome of this action at law. If there is no sheriff, then there is no chief law enforcer of the counties in question, and people will be at the mercy of politically controlled code enforcement officers enforcing unlawful municipality statutes in courts not of record upon the people without mercy, where everyone is guilty and fleeced of their property. You're always found guilty there. They always take your money, your property, put you in jail. That today is hanging on by a thread. These Nisi Prius courts are self-serving and economically serve to grow more and more power and authority to villages, towns, and cities that have no constitutional authority to do so. We, the people, are also at the mercy of any federal officer that enters the county, that all too often abuse the people with unconstitutional authority. City, town, villages, and state police forces are a relatively modern invention, sparked by the changing notions of public order, driven in turn by economics and politics. As the nation grew, however, different regions made use of different policing systems. State police are hired, served, and answer to the governor. City police are hired, served, and answer to the mayor. Town, village police are hired and served and answer to town boards. And we know what that's like. All of which unlawfully enforce unlawful statutes written to economically serve the municipality and control the behavior of the people, a nuisance to the people. Black law defines police officer as one of the staff of men employed in cities and towns to enforce the municipal policies, the laws, and ordinances for preserving the peace and good order of the community, otherwise called policemen. Therefore, appointed or police employees answer to statutes, regulation, codes, and to whatever political boards of individuals that hired them, all of which are constitutionally ignored and abusive in their alleged authorities, whereas an elected officer of the law is hired by the people and answers to the law and the people, a protector against these barrages of nuisances. We, the people, are subject only to the laws of nature, of nature's God. The common law permits destruction of the abatement of nuisance via summary proceedings. It is not the government's duty to govern the people's behavior. At the Revolution, the sovereignty transferred to the people, and they are truly the sovereigns of the country. But they are sovereigns without subject, with none to govern but themselves. See Memorandum of Law, Sovereign Authority attached. We may read that one evening. The memorandum that's attached to this. We will post it up later on. Police receive their arrest authority from legislation and in reality make citizens' arrests. All too often these arrests are unconstitutional. The final arbiter of the arrest is the sheriff when they are delivered the accused to the county jail, whose job it is to protect the rights of the people from overzealous code enforcement officers and city, town, and village courts that depend on the revenue generated by these code enforcement officers that they empowered. Now, our sheriffs are so ignorant; they don't understand that. That's why it's so important for people to get involved with this, and get involved with, our campaign for constitutional sheriffs, and help get these papers into the courts. And let's start the battle. Let's put it together. It's got to be done before the end of the year, because we need to be off the gate running. We have to have our courts prepared. It's got to be laid out specifically what a court of record is and all the different subject matters that we're covering and what needs to be done and what they need to stop. They need to open the doors of justice. The sheriff, being the chief law enforcer of the county, is hired by the people and serve and answer to the people by preserving the law of the land and protecting the rights of the people. Sheriffs are authorized and empowered by law of the land, also known as natural law, whose power and authority is also confirmed in Mack versus the United States. Most state constitutions require by law the election of a county sheriff. And that's not necessarily true anymore. There's all kinds of problems, and we already read the states that have the problems, and there are 27 states with problems. So, what does that leave us? 23, I think, left that are obeying the law. And I'm sure, some of those counties I may not even have had information on and may be already gnawing away that I'm not aware of yet. The sheriff is an officer of great antiquity, dignity, trust, and authority. He was chief officer to the king, today the people. Within his county, no suit began, no process was served, but by the sheriff. He was to return indifferent juries for the trial of men's lives, liberties, lands, goods, etc. At the end of suits, he was and still is required to make execution, which is the life and fruit of the law. The powers and duties of the sheriff, as implied from the name and nature of his office, are still the same today under the common law. He is still an officer of the court and subject to its orders and directions on behalf of the people. The sheriff is still made responsible as conservator of the peace. Without the sheriff, there is lawlessness, because the sheriff is the only law guardian, without which there is no peace. America cannot exist without an office of sheriff. The county sheriff is a fixture of the common law, well established in history, a constitutional officer elected by the people, bound by oath as guardian of the people, people's unalienable rights, the vested rights of the state, and the law secured by the Constitution. If the office of the sheriff, the protector of rights, were removed, the way for abusive government would be paved, resulting in the banishment of law, banishment of unalienable rights and invested rights, and we, the people, would become the servants and playthings of tyrants. Inherent attributes of the Union envisioned in the Constitution. The United States is a common law republic. The Declaration of Independence is the foundation of American law that is built upon the laws of nature and nature's God. Article 4, Section 3, Clause 1 states, new states may be admitted by the Congress into this union. The equal footing doctrine is a constitutional requirement and not merely a statutory interpretation of Congress' act of admission. The Supreme Court has held the sovereign equality of the states to be an inherent attribute of the Union, envisioned in the Constitution. The constitutional basis for the doctrine was clear, at least by the 1845 decision of Pollock Leases versus Hagen, if not before. With that said, it goes two ways. When a state joins the Union, the state must conform to the law of the land. The law of land, due process of law, and due process of law are synonymous. Article 4, Section 4 requires states to have a republican form of government. Article 6, Clause 2 requires that every state shall be bound to the supreme law of the land. Article 3, Section 2 provides for two jurisdictions on the land: law, which is common law, and equity, statutory law, legislated law. Equity provides for legislation to be written to control government agencies and commercial activities, whereas the people are under the laws of nature and of nature's God, also known as common law, regardless of Rule 2, which is in violation of Title 28, subsection 2072B, Declaration of Independence, Article 4, subsection 4, and Article 6, subsection 2, Amendment 7 and Amendment 10. Due course of law. This phrase is synonymous with due process of law, the law of the land, and means law in its regular course of administration through courts of justice, where rights are secured by the Constitution. Where rights secured by the Constitution are involved, there can be no rulemaking or legislation which would abrogate them. And all of the federal all the rules of every court violates them, every single one of them. Common law demands a constitutional law enforcement, known as the sheriff, vested by common law with all powers and duties of sheriffs implied from the name and nature of his office, an officer of great antiquity, dignity, trust, and honor, and authority. The sheriff is the last line of defense against the rogue government agency. He is the protector of rights, enforcer of the land, the law of the land. Common law and common law founding documents cannot defend itself. A constitutional officer is the only defender of the law. Only the county sheriff can fulfill that role. There is none other. Without a sheriff, our natural law republic is in jeopardy, especially today with the out-of-control federal agents such as the FBI, the DEA, the ATF, and DHS. The county sheriff's nemesis are the municipal police forces. It is claimed that police are the function of that branch of the administrative machinery of government, which is charged with the preservation of public order and tranquility, the promotion of the public health, safety, and morals, and the prevention, detention, and punishment of crimes. Acts of an officer which are to be deemed as acts of administration and are commonly called administrative acts and classes among those governmental powers properly assigned to the executive department are those acts which are necessary to be done to carry out legislative policies and purposes already declared by the legislative body or such as are devolved upon it by the organic law of its existence. These statements may hold true if they did not apply civil law upon the people. In order for a municipality to enforce statutes upon a free and independent people under the guise of necessity, they needed a police force because the sheriff would not and should not enforce statutes that control the behavior of the people. The sheriff will, however, enforce statutes upon government agents or agencies and their agents and those operating under commercial activities. Therefore, all police forces are code enforcement officers that serve the government and not the people. Newly sworn local and state police officers take an ethical pledge that is called a law enforcement oath of honor. Separate from the law enforcement code of ethics, an oath written by the governing board of the International Association of Sheriffs of Police, both of which is in conflict. And I wonder if they take an oath to the Constitution. I haven't seen that. Which their conflict with their constitutional oath, that's presumed. If a police officer holds a constitutional position over the will of the government, they are dismissed, whereas sheriffs are not conflicted by two oaths and do not answer to government agencies or their agents. They are duty-bound to uphold the Constitution and answer to the people at the ballot box or be recalled. In conclusion, a county without a sheriff is a lawless county. We have natural law republic form of government, guaranteed by the United States Constitution, Article 4, Section 4, which means rule by law under our common law Constitution. Common law provides for a sheriff that dates back to at least 871 AD. And actually, you can find sheriffs going all the way back. I remember whether it was 500 or 600 BC. There cannot be any let me step back a bit. Because a common law sheriff must be free and independent, there cannot be any legislation that can define or restrict his power. Therefore, the sheriff is a fixture of the common law and part of our common law due process, and the final arbiter of what the common law is in his county. Without the county sheriff, there is no protector and champion of our common law Constitution. The powers and the duties of the sheriff are, as implied from the name and nature of his office, are still the same today as they were throughout history. The sheriff being the necessary chief law enforcer of the county, whose office cannot be abrogated or abrogated by referendum, legislation, or even constitutions. There are many constitutions out there that don't say anything about the sheriff. There are some constitutions that abrogated the sheriff. It's pretty bad. We need to do something about this. Nor can a sheriff's power be diminished by legislation, courts of federal or state, or constitutions. The sheriff receives their power from the laws of nature's God and are elected by the people and therefore do not answer to government agencies. The sheriff is the only law enforcer responsible for executing all lawful warrants. The sheriff also has an obligation to protect the unalienable rights of the citizens. They are the people's enforcement. The county sheriff is the last line of defense when it comes to upholding and defending the Constitution. Without the free and independent common law office of the sheriff's common law, Without the free and independent common law office of the sheriff, common law has no teeth. Standing. The loss of one sheriff is a threat to all citizens that live in or travel through a lawless county. To permit lawlessness to prevail in one county is a threat of lawlessness in all 3,134 counties, because the cancer does not stop until the entire body succumbs to the death. We, the people, now see the threat, like a cancer moving across America, and are in jeopardy of losing the protection of the law. Of the 50 states of the Union, 27 states, that's 54%, are already in a state of imminent jeopardy. Plaintiffs are more than 11,449 grand jurists, many of which live in counties without sheriffs or whose powers are diminishing. We are the sureties of the peace on behalf of all the people. We are the people of the United States of America, clearly having standing in all courts of record, such as this one. We, the unified United States common law grand jury, via the presentment demand that the defendants obey the law of the land and restore the fully informed and fully empowered county sheriff. Causes of action. Now, I may not read through all the causes of action, but I'm going to read through a little bit, at least this one with this Judge Lewis. He's the only individual mentioned. Everyone else we copied was, again, going out to legislators. We addressed it to the speakers of the House and counties, depending on, I looked up to see what powers or authorities in those different counties, whether it was a board or some other authority. But anyway, the Constitution for Virginia, Section 4, states that the sheriff shall be elected, not appointed, by qualified voters of the county as per Title 24, subsection 2-22, 8.1. which provides for constitutional officers' vacancies to be filled by a special election. In September 2023, the Sheriff of Virginia Beach County resigned his position for medical reasons, and Rocky Holcomb was unlawfully appointed and sworn in as sheriff by Chief Judge James Lewis in October 2023, whereas the governing body, Chief Judge James Lewis, and City Clerk Tina Sinnen did not follow the law, and the appointment and oath were unlawfully accepted and filed on the record by the elected City Clerk Tina Sinnen, without providing for a special election in violation of the law, subsection 22281C, which states, upon receipt of written notification by an officer or officer-elect of his resignation as of a stated date, the governing body may, now it may or may not, immediately petition the circuit, or they can do it at a little later time, they immediately petition the circuit court to issue a writ of election, and the court may immediately issue the writ to call the election. Now, there's a little more to that, and we're going to read a little more. Whereas the governing body did not petition the circuit court to issue a writ of election, and the court did not immediately issue the writ to call the election. In some cases, ignoring the law and placing into power, such as Virginia Beach, with a government-desired CLEO that owes his allegiance to the government and not the people. Subsection 22281B provides that, now this is the addition to the law, if a vacancy in any elected constitutional office occurs within the 12 months immediately preceding the end of the term of that office, you see, then they can decide not to go for the special election, or they can decide to go for it. And they can, appoint to someone, maybe, the undersheriff or somebody. But once it's further than 12 months, that becomes a problem. So let me read that. If a vacancy in any elected constitutional office occurs within the 12-month immediately preceding the end of the term of that office, the governing body may petition the circuit court to request that no special election be ordered. Upon receipt of such petition, the court shall grant such request. Because the next election is in November 2025, being 25 months till the end of the term, that may is irrelevant. It now becomes a shall. Being 25 months till the end of the term of the office of sheriff, the governing body was not at liberty to petition the circuit court to request that no special election be ordered. They should have put the papers the opposite way. Now I'm just going to read a few of these so I can move along. Let's say Virginia State, the Virginia sheriffs are elected unlike other states. The sheriff is not the chief law enforcement officer in a city that has a police department. A chief of police has that distinction according to statute. In such areas, the chief of police is the highest ranking officer. That's amazing. That's Virginia, the entire state. Every city there is in jeopardy. New York State Constitution, subsection 13A. The sheriff and the clerk of each county shall be chosen by the electors once in every 3 or 4 years, and they legislated 4 here, as the legislature shall direct. Whereas the sheriff of New York City, Manhattan, which is, we're going to list them out, Manhattan, Bronx, Brooklyn, Queens, King counties. There's 5 counties. They're called boroughs down in New York, but boroughs are still counties, that have just one appointed sheriff. So one sheriff controls all 5 counties, and he's appointed, a sheriff appointed by the mayor, who applies statutes in place of the law. Nassau County Sheriff and Westchester County Sheriff are appointed by the county executives. So here in New York, we have a problem in 7 counties. Alaska has no. Alaska state constitution nor legislation does not provide for a sheriff, and there is no sheriff. Connecticut State, the House voted 147 to 2, unbelievable, 147 to 2, to put a constitutional amendment eliminating the office of the county sheriff to a statewide vote on November 2000. The Senate overwhelmingly passed the measure and it didn't need the governor's approval, because both houses had 2/3, better than 2/3. Delaware states, I'm not going to read all these states. Hawaii has no sheriffs. Pennsylvania's in trouble. Rhode Island's in trouble. Delaware's in trouble. Pennsylvania, I mentioned that. Kansas in trouble. Colorado is in trouble. Florida, Indiana, Kentucky, Louisiana, Maryland, Massachusetts, Michigan. Michigan also has a problem. Montana, Nebraska, Nevada, New Jersey, New Mexico, Tennessee, North Carolina, Washington, West Virginia, South Dakota. Conclusion. The general rule is that an unconstitutional statute, though having the form and name of law, is in reality no law, but is wholly void and ineffective for any purpose, since its unconstitutionality dates from the time of its enactment. In legal contemplation, it is as inoperative as it had been, as if it had never been passed. Since an unconstitutional law is void, the general principles follow: that it imposes no duties, it confers no rights, it creates no office, it bestows no power or authority on anyone, it affords no protection, and justifies no acts performed under it. A void act cannot be legally consistent with a valid one. An unconstitutional law cannot operate to supersede any existing law, indeed insofar as the statute runs counter to the fundamental law of the land, which is the Constitution. It is superseded thereby. No one is bound to obey an unconstitutional law, and no courts are bound to enforce it. Bonnet versus Villaire. Federalist number 78, page 525, Hamilton. As Chief Justice Marshall declared in the foundational decision of Marbury versus Bannerson, it is emphatically the providence and duty of the Judicial Department to say what the law is. In decades following Marbury, when the meaning of a statute was at issue, the judicial role was to interpret the act of Congress in order to ascertain the rights of the parties. Decatur versus Paulding. Today, it is the duty of the court to guarantee to every state in this union a republican form of government, and shall protect each of them against invasion. Article 4, Section 4. Decency, security, and liberty alike demand that government officials shall be subjected to the same rules of conduct that are the commands of the citizens. In a government of laws, existence of the government will be imperiled if it fails to observe the law scrupulously. Our government is the omnipotent teacher for good or for ill. It teaches the whole people by its example. Crime is contagious. If the government becomes a lawbreaker, it breeds contempt for the law. It invites every man to become a law unto himself. It invites anarchy. To declare that in the administration of a criminal law the end justifies the mean. To declare that the government may commit crimes in order to secure the convictions of a private criminal would bring terrible retribution. Against that pernicious doctrine, this court should resolutely set its face. Olmsted versus United States. Judges have no more right to decline the exercise of jurisdiction which is given them, to usurp that which is not given them. The one or the other would be treason to the Constitution. The sheriff is the lawful chief executive officer, the highest peace officer of the entire county in which he was elected. Unlike the state police and municipality police, the sheriff reports directly to the citizens of the county. In today's terms, the sheriff is the chief law enforcer in the county. The duties, responsibility, and authorities of the sheriff cannot be diminished by those in the legislature or the courts of the states or of the county. Wherefore, and this brings us to the end, the wherefore clause. Now, I may rewrite this wherefore clause. I've been through it numerous times. I've looked at it from different perspectives. Right now, I'm kind of comfortable with what I wrote here, but we'll see. It may change. We may tweak it back and forth a little bit. Wherefore, on behalf of all the people of these United States, we, the Unified United States Common Law Grand Jury, the sureties of the peace, move this court for declaratory relief as follows. All 50 states, when joining the Union, agreed to obey the supreme law, common law of the land, and thereby establish a republican form of government that requires a common law enforcer in every county. whose powers cannot be abrogated or diminished by state constitution or legislation, whereas anything in the Constitution or laws of the state of any state to the contrary notwithstanding. The powers and duties of the sheriff is vested by the common law, whose powers are delineated in history and implied in the title being the chief law enforcer of the county, chief conservator of the peace, and chief executive and administrative officer of a county, with no term limits, where thereby being a fiction. And that's important because some states have limited the terms, how many times a sheriff can run for office. That statutorizes something that's part of common law. That's not possible. That's a conflict. That's oil, trying to mix oil and water. It's up to the people to decide whether they like their sheriff and want to keep him or not. Thereby being, well, let me back off. Well, that's it, yeah. Chief Executive and Administrative Officer of the county with no term limits, thereby being a fixture of common law elected by the people and unalienable rights. States and their respective counties must conform to the supreme law of the land by safeguarding the common law Republican form of government via the election of a sheriff in every county for the securing of justice, domestic tranquility, and the general welfare, and the blessings of liberties for ourselves and our posterity. Any county without a chief law enforcer is a lawless county. All defendants are to restore the CLEO to power and or follow the election laws that will accomplish that goal. And then it's New York. It's going to be posted up in Albany County and signed by a grand jury foreman. Again, grand jury presentment for a declaration and an order. Okay, so that brings us to the end of that, and I will post that up eventually. I'm not sure where I put it, but maybe by next week I'll have it up, and I will tell you where it's at. And then these other papers that we'll be writing, we'll do the same thing. We'll post them in the same place. But again, just as an example, okay, a rough idea. I think I made some notes. I'm not seeing them, so maybe I didn't. Okay, but basically this is the case. We have 27 states that have to be served. We have, I think, 30 some odd counties or 40 counties. Let's say 35 counties, roughly speaking. We have law enforcement that is going to be also. We have JAG. We're going to be sending it to. We have law enforcement, three law enforcement, one for the Army, the Marines, and the Navy, I think. I think that's what it is. I don't remember, but JAG is also in there. So they have to be served. The United States Supreme Court, going up to them, I just spoke with a couple of people who have a case up there. They're requiring 40 copies, okay? So we have to make 27 copies, plus 35 copies, plus 40 copies, and let's see, what else? And then law enforcement, another 4 copies. So we're looking at 7, 10, 11, 16, 3, 6, 9, 10, plus the 40 going up. We need 146 copies. Now, I'm guessing that 146 copies sent certified mail, probably at least $20, $25 a copy, considering the paper, the ink, and the mailing. So let's say it's $20 for right now. That's $14.60 times 2 is $28, $29. So it's $3,000 just to do the serving. We need $3,000 to serve this. Okay, we need, I believe, to go into the federal court. Last time I went, I think it was $400 or $410. So let's say $410. Okay, that's filing in through the basic courts, but to head through the appellate process and go into the United States Supreme Court, I know going through the appellate process, they want $600. Now, I don't know if that's going to be required or not, but if it is, it's another $1,000. So just to do this one case is $4,000. Now, I want to tell you what this case would cost if you had lawyers. You'd be looking at $1 million. There's no doubt about it. Okay, you go listen and watch and see what's going on. To go into a federal court just to file a paper, they want $30,000, $40,000 down. Okay, and they start eating away at that for every little thing that they can charge for. So look, we're getting a real good deal to save our republic. a real good deal. Can we, the people, come up with $4,000? Look at what happened with Trump recently, and look what's happening going to court. People are sending him money, and rightly so, and we need to do that. I mean, even the poorest of poorest is trying to get out 25, 50 bucks, 100 bucks, whatever they can get out. I know everybody I know is doing it. I've done it. Send a few dollars in. I can't afford much, but I send 100 bucks here or there. So everybody's doing something like that. How much more for this too? Okay, can you minus what we get through donations, which isn't even enough ultimately to cover everything that we have. Again, my books, the money coming in from my books goes into NLA, and before I take any of that money out, I make sure all the bills are paid and everything's covered for. And so I may be able to pull 20-25% of that money out from time to time for myself and my family. But in any event, okay, even everybody who's already given money, this is something different. We need money. We need to get this paper out. This is one paper now. We have 9 more papers to file. Okay, we don't have that many to serve though, so it won't be that expensive. But still, we're talking maybe $1,500 to $2,000 a serving. We need money. Okay, we also let me think about this. Well, I guess that's it. We need money. Oh yeah, we also need $3,000 to upgrade our website. There's something big coming up we've been working on in the background. We're hoping it's going to turn out to big. We can't talk about it now, but we will talk about it probably by mid next month, which is going to bring us to the attention of, if all is what it's planned to be, almost overnight it's going to bring us before millions of people. Well, what we're doing here is going to be put before millions of people. We need 300,000 people to save America through what we're doing with National Liberty Alliance, building the committees of safety, teaching people, and look at all the courses and everything we teach is free. Okay, I mean the law course we charge $125 for. It's a great course, and that brings in more money. Again, that money goes into National Liberty Alliance. Even though that's my course, I put it together. It's my intellectual property, and it's my sweat to put that together and everything. But it goes into NLA first. And again, if there's anything left over that I could take, I do take to survive myself. But the bottom line, but again, a lot of it goes into the NLA. Before we would even getting donations, I was supporting this whole process. It was, just me doing it. It wasn't as expensive as it is now because we've grown so much. We've got a lot of different expenses, to change monies over to go from the, through the credit cards. We need a link going to the bank. That costs money. We have a service that takes care of the credit cards when they expire. They set forth for the renewal. Okay. Our email, when we send out email, it costs us money. Every time we send out email, it costs us money. And if we have to start sending out email to 500,000 people, it's going to cost a huge amount of money. We have to pay for broadband. We pay for our euros. We pay for our space. We pay for keeping the lights on. We pay for the website to be taken care of. There's a lot of expenses involved here. So there is no money there coming in through donations to do what we have to do. What we have to do is above and beyond that. So if people are serious about saving this nation, if it's that important to save this nation, then we're going to get these papers filed. And like I said before, if people don't support this, then the people have spoken and they're not interested in saving the republic, because there is no other way. Look at Trump, like I said, he can move the military, he can do what he's got to do, devolution can play out, and he can give government back to the people, and then what? Then what? What are the people going to do? You're going to lose it anyway, because you can't even control it. People do not know, and I speak to myself first, people do not know how to have government by consent. I have learned how to have government by consent, and I'm executing that government by consent. And that's what NLA is teaching the people, government by consent. You need to learn to have government by consent. You need to put time into into our nation. We have government by consent. If you don't participate, then we don't have government by consent. It is true that we have government not by the majority, but by the majority that participates. So it's going to be the majority that participates. The 300,000 people, 100 people per county, 300,000 people is what we need. That's just a very, very small sliver of 1%. So we don't need a lot of people. But we do need people who are serious, people who are going to educate themselves, people who are going to get active in their communities, people who are going to take their schools back, take their government back, one government at a time, your town, your village, your cities, your counties, your state, and the federal government, to take it all back. We teach you how to do all that, and it's free of charge. There are a couple of courses that we require people to be, premium members. Premium members, someone give them $5 a month or more. But we have always opened the door to people who say they can't afford that. We let them in for free. We give the course, the law course, to any sheriff that comes on board. They get it for free. Sheriffs and their deputies, they have it for free. Once they sign up and we know that they're a sheriff or a deputy, they got access into the court. We don't charge them. Okay, so again, only the people can save America. If a people expect to be ignorant and free, they expect what never was and will never ever be. Just forget about it. Ain't happening. Okay, with that, we'll take some questions. Hopefully we're going to stay on subject tonight because this is an important subject, talking about this or other things that we are doing. Let me see. Did I open up the queue? I guess I didn't. I'm sorry. Okay, anybody that wants to get into the queue, it's a *6 and a 1 if you're on a phone, and if you're coming in with an app or a browser, there should be a little button there to click to get into the queue. So queue is open. We've got one person in the queue. So again, we're open for questions, comments, or corrections, thoughts, ideas. So we'll take our first caller here. Let me see if I don't want to hit the wrong button. Okay, there it is. Okay, Anthony, you got the mic. Go ahead.
Hello, John. How are you doing?
Good. Anthony from West Virginia.
Yes, it is. I see you recharged your PayPal account this week. I finally signed up for the law class.
Yeah, PayPal has been working. We don't get much through that because we don't really do a membership through that. And the reason why is because you hit $1,500, they shut you down unless you do certain things which require you to make communications with the IRS. I know Sheriff Mack had that problem. That's how I learned about it quite some time ago. And we did have some problems with them, but we do get little donations from that, but we don't get much, and we veer people away to just use credit cards or debit cards or send in a money order or a check or something. So PayPal.
Would you prefer that I just dissolve my PayPal donations and give a different way? Because apparently my donations that I've been giving all these years finally went through just this last week. You didn't have me on as if I was even a donating patriot.
Yeah, well, right here, if you go to hit the donation tab, there are different ways. You become a monthly donator. You can give a one-time donation. And if you become a monthly donator, then the only way to do it is through a debit card or a credit card, okay? And so you give whatever you want to that way. The other way, of course, a one-time donation the same way. Or again, you can do by check or money order. So by clicking on the donation tab, it will tell you the ways that we can receive money. We take MasterCard, Visa, American Express, and Discovery. PayPal, we don't take, but we have had some people in the past that were on it, and we let that go, and hopefully, and we've been getting a little bit of money, but not much from them. We probably collect maybe about if we collect $100 a month, we collect a lot on PayPal.
Well, I may be confused then. I spoke with Jan. You see, I've been giving through PayPal since, I think, 2014. With PayPal, did you clear up that account? Were you able to get the money that I had collected there?
I don't know. I'd have to. I don't even know if I can find out. Don't worry about it at this point. But the thing is,
we're talking about maybe $1,200-$1,400.
Well, again, I'll see what I can find out. Can you find out? I mean, you have an account?
I did. I called PayPal. PayPal said that the money is there, and you were having problems accessing your account.
Well,
and so
that's not true.
All you need to do is solve that problem, whatever it is, about accessing your account.
Well, that's not true. That's not true. I check PayPal maybe once every couple of weeks to see what goes through there. What goes through there is about $100, roughly speaking, a month. And we get a lot of people that have come on PayPal, but they don't put money in the account, so the money doesn't come through. Okay, so we don't get it.
She told me that the money is there, and I said, well, how can I get the money back? And she said, well, somebody from NLA, the officer that handled the PayPal account, would have to authorize a refund, and then the money would be sent back to me. Now, I understood with communication with other top officers there at NLA that you had already accessed those funds.
Yeah, well,
I don't want to.
I'm not. Look, if you had money in the account. In other words, look, when you know how a PayPal account works. You have to attach
an
account, or you have to put money in from time to time. Now we've had a lot of people who came through PayPal, and then they never put money in the account, so we never collected it. Okay. Now every once in a while I'll get a note. I'll get a lot of notes like this. You didn't receive a payment from this person, so on and so forth, and it shows how much that it goes back to, how much money. I'll check to see if there's anything in there. I mean, either your money's been going or hasn't been going.
She told me, and the accounts there's two accounts. I opened one account in, I think it was 2014. It was January 2014. And then in September of 2021, I added another $5, so I was given $10 since since September 2021.
Why don't you send me your phone number to mail, MAIL, at nationallibertyalliance.org, and I'll give you a call tomorrow or the next day. Tomorrow's a big day. Yeah, let's see if we can figure out what's going on with that. But it's not sitting anywhere unless it's sitting in your account. It's in your. She said it's in your account, but you're having trouble accessing the funds. I have no idea why they would tell you that. I have no trouble accessing PayPal. I have no idea.
I don't know what she's telling me. We'll have to.
If you have information to that contact, we'll talk about that tomorrow. I'll call them.
Let's do that. Okay. So, in interest, like time is moving on. I've got a quick question. For my family. After I let you know I have 89 hours left to do on the 90-hour course. So anyway, that's good. My grandfather was illiterate, and way back when I was a boy, somehow my grandfather's property was stolen from him by someone who convinced him to put his mark on a piece of paper. And I'm wondering, when we come to devolution, is there anything I can do if I could dig up the right information about this transfer of money to get that land back?
Well, look at in common law, there is no statute of limitations. The only thing that limits a case from going forward is witnesses are no longer available. The evidence has been lost. You can't make a case. So under those terms, you can't do nothing. But if you have the evidence, there is no statute of limitation on anything.
Well, I'm going to dig up because my dad did some work. I didn't even know if he was doing it. I found out later, of course. He was trying to help my papa get that land back, and he ran into a lot of dead ends, but I think he had some evidence, and I'm going to look for it anyway.
Yeah, well,
just thought I'd ask.
If you find it, we could talk a little bit about it. But with that, we need to move on unless you got something else. Hopefully focusing.
I don't have anything else, John. Thank you so much. Talk to you next week, maybe.
Okay. Okay, next caller. Ross, you got the mic right ahead.
Hey, John, you can hear me?
I can hear you.
Sir, I'm trying to go about doing the passport stuff, and someone say they think, can we get ourselves out under the 14th Amendment, be a citizen, a 14th Amendment citizen? I would rather be a Article 4 citizen.
Well, look, the 14th Amendment is tricky. Okay. Now, the 13th Amendment and the 14th Amendment should have been brought together as one. At the time they made two of them, and they separated the 13th, so they hid the original 13th Amendment with part of the 14th Amendment, and that's how they hid it, which we have to resurrect. But as far as the citizen, it's a matter of interpretation. If you want to interpret that as a citizen of the United States of America from the standpoint under common law, then we're one of the people. They, of course, are playing a game with words and trying to change the meaning of a citizen, putting you under their thumb and their statutes under the laws of the city. So that's a game they play. It's a fraud. We should not be running away from it, but we should be running to it and assaulting the fraud in the courts. And that's what we're doing. We're making the courts, and it doesn't matter that we're not winning right now, because look, George Washington lost most of the battles, but he won the war. That's the key. We've lost a lot of battles, and we've only won a few battles here and there, just like George Washington. But we will win the war. All of these battles collectively are put together. Every one of those battles is a nail in their coffin, and we will get back everything. I'm confident of that. Once we have the and we do have enforcement. Enforcement is the military. JAG is the enforcement. We have that enforcement.
Yeah, I was thinking we need to remove on a U.S. passport form, remove the U.S. citizen.
What do you need a passport for? You're going to be traveling out of the country?
No, my mom wants me to have a passport and a passport card.
Okay, and so you need it in case you have to go out of the country for one reason or another. So go get a passport. Don't worry about the wording. You're a citizen of the United States.
U.S. citizen is a different status.
No, it ain't. No, it's not a different status. No, but they're trying to make it a different status. Look, I'm very familiar with what's going on with that citizen thing. And I understand they're playing a game with citizens, and then people are getting frightened of that word, and they're running away. No. We go into our courts. Those are our courts. Those are courts of record. We're opening up courts of record. It doesn't matter what they say it is. We know what the Constitution says it is. Same thing with the word and the meaning of citizen. A citizen of the United States of America is one of the people. That's what it means. We're under the authority, ultimately, of common law. It's clearly laid out in the Constitution. So again, they do play a game with this citizen thing, trying to make it mean something else in their statutory processes, so that they can execute their fraud on us. They're defrauding us. But that's all going to go away soon. We have to stand up and protect the meaning of words. We have to protect our Constitution. We have to protect our government. We have to protect our courts. We have to resurrect them all. Okay, we have to get rid of the bar. We've got to get rid of all this craziness. We have to make nullified, and that's what the Republic Review that we support is working on, is to nullify all unlawful statutes, unlawful legislation by the U.S. Congress. And we're working on that. I know, again, Republic Review, GR from the Republic Review is working on that.
Because I did use AI, and I asked contrast citizen of the United States with the U.S. citizen. U.S. citizen of the United States is the historical context, and that's the original citizenship.
What is it? This citizen what? What is it?
Citizen of the United States
Yeah, it what?
is the original citizenship. Your citizenship,
Well, yes, of course. We're the people. We're
yes,
citizens of the United States.
that your citizen is owned by Washington, D.C.
Well, if you want to go into the corporation, there's two
Yes,
United States. There's two United States. There's the United States Inc. That is what they've created, and they've tried to put all this system under that and play with the legislation and do some wordplay. It's called legalese and play all that game,
yes.
go rabbit holes.
That's what the
That's
legal
all
is.
a fraud, and that's what we're fighting against. That's what we're revealing. Don't look at people who go through all these exercises, okay, to get rid of their birth certificate, get rid of their driver's license. You know, we had a guy that was coming to one of our meetings. He had done all those things. He made his declaration, filed it in the county. He got rid of his driver's license, got rid of his or worked on his birth certificate or something. I don't know what he'd done there. Going through all those processes. So how does he get to the meetings? Well, he has to go to someone else. Literally, he does go to someone else to drive him around. He won't drive a car. Okay, I mean that's insane. All right, why? And what is he doing? He's playing in their sandbox.
Yes,
They
but
tell.
the driver license is a legal entity.
I get emails all the time, or once in a while anyway. I get an email from time to time telling me all this stuff, that you're going into their sandbox, you're playing in their courts. What are you doing going in their courts? No, I'm not going into their courts. That's our courts. They may have stolen them from them. They may have it under hostage. They may have closed the doors of justice, but we're still able to file papers and make cases. And all of that is evidence for the end game. And the end game is the end of this year. It's coming up. And it may happen quicker than that. We have a lot of
Yes.
work to do. The question to the people, are we going to do the work that the people need to be doing? Are we going to defend the Constitution? Are we going to defend our republic? Are we going to defend our sheriffs? Are we going to take this nation back? Are we going to educate ourselves so that we can exercise government by consent? Are we going to take our schools back so they don't keep demoralizing our children? What are we going to do? You know, people got to step up and do something. Time has come. This is it. And let me tell you, people have not been stepping up. I'll tell you right now, they haven't been. Yeah, we have people working here at NLA, and they're working their tails off. A lot of people that, the people that are not working or retired, they put a lot of time in. People are working, put as much time as they can in. But it's not enough. We need more volunteers. We need more help. We definitely need money. We can't save the nation without money. Look at Trump. He's asking for money all the time. And he's a billionaire, and you might say, why don't you support it all? It's not his job to support it all. You know, it's up to the people. We have to do it.
Yeah, the problem, the state of New York tries to take all his $1 billion away from him.
Mm-hmm. Yep.
And did they yet take it away from him?
Yeah, I don't know where that's at. I heard recently that he won the case, and I think he was talking about that case, and I'm not sure. So there's so much going on.
It's like the immunity case he won.
What was that?
The immunity case.
Yeah,
He
well,
won
that's one case. But what about the case where they're coming after him for some silly charges to put him away for 100 years? I think I heard something just a couple of days ago, over the weekend or something, I think. Well, they said something about winning a case, and I think that was the case, that it was just closed down. So, but I don't know if anybody heard anything on that. Let me know. I don't know.
Okay.
My head is buried into research and writing for weeks now.
Okay. Yard.
You done, Ross?
Yes.
Okay, thanks. And if you want to get a passport for good reason, no reason why you can't. It's not going to...
I was thinking about saying no on that form as
No,
a citizen.
they're not going to let it go through then if you say no. They're going to say, well, what are you a citizen?
Yeah, actually, other people get their passport that way. So you have to do explanatory statement, explain
Well, look,
why.
don't go through their hoops. Just go do what you got to do. we're working to win it back, and no matter what you do, they're still going to enslave you anyway if they win, and they're not going to win now, and I wouldn't worry about it. So,
this guy I listened on YouTube, he said he was successful of doing it like that.
yeah, I wouldn't people talk about these things, to be honest with you. They're all, I've look at, they're all problematic, I'll tell you that. And I used to believe this stuff, and I ran down with them, but I'm not a person to run blind. I did, to an extent, run blind, believing a lot of things, but as I digged for myself, I started to find a different perspective of the thing. This is not about what they're doing. They're going about, they are doing what they want them to do. That's what they're doing. But in any event, we don't teach that stuff, and I wouldn't worry about it. Okay? All right. Thanks for the call, Ross.
Okay.
Our next caller. Okay. Ken from New York, you got the mic. Go right ahead.
Good evening, John. This is Kent. Can you hear me okay?
Yep, we can hear you.
Yeah. I want to thank you for any advertising you did and for the conversations we had regarding the support of the barbecue. We did print up your brochures and make them available to people, and we got about 8 people that came from Massachusetts, Connecticut, Pennsylvania, New Jersey, and New York via the networking process. Exactly what groups they represent, because some people came from several groups or were connected with several groups, I don't know. But in any case, we appreciate you and your staff and what you did to promote that barbecue and the networking effort. And we've gone over with the founder of that organization. I spent a couple hours going over with him how it could be improved in future years as far as networking goes. So, again, thank you very much.
Okay. You're welcome. All right. That's it, Ken. Appreciate it. All right. We'll take our last caller here. It looks like Andrea. What state is it?
Yes, can you hear me?
We can hear you. What's your state?
Okay. I have tried to send in 3 different affidavits, and I clicked on the link that you have, and it bounced back, and it says that there is no one at this address. I have...
hold on. What are you talking about? Tell me what, and I'm going to follow through. What link did you click on?
The one on the page. I copied it. Sorry, I copied the link on the front, on the main page.
Okay, so it's on the front page. Okay.
Mm-hmm.
And what link?
It's the Restore affidavit at restoregovernmentbyconsent.org.
Okay, I'm looking for that. I don't have...
Hold on just a second. Let me go.
Yeah, I'm not seeing anything with Restore.
It's, hold on just a second. It's today's issues, and then...
Okay, today's issues. Go ahead.
Stuck in... My internet's really slow right now. Stuck in...
An abusive court.
Abusive court,
Okay, and the affidavit, if you click on it down, as you get down here, you get download MS Word affidavit, docx format. Okay,
yep, I
click
did
on
that, and then
it
I
opens
had it notarized. I had it notarized and everything. So I tried to bring up the email so that I could have it emailed to y'all.
Okay, you know what? I may have to change this where to send it, because you see that link is not active yet, because we're still waiting on the people put this website together.
Right. It said there was no one at this address.
What I'm going to do is I will change it to nationallibertyalliance.org. We'll create a place for affidavit at nationallibertyalliance.org and let it go there instead of going to that one. Okay?
Okay.
And so this week, I'll try to do it tomorrow, the next day. I'm really busy. I got so many things going on in the next, 36 hours or so. So, but I will fix that. Okay?
Okay, I've been sending people to the link. So I have 4 other people that are wanting to do affidavits as well. So I'll get the message out to them to keep an eye out for it and to, not give up. So they've just been sending it repeatedly.
Okay. All right. Yeah, I'll
That sounds great. Thank you very much, sir.
okay. All right. We have the other person in the queue. Thank you, Andrea.
You're welcome. Thank you. You're welcome.
You're welcome. Okay, let's take our last caller, Dawn, it looks like. What state you from, Dawn? You got the mic.
Hi, can you hear me, John?
I can hear you.
Hey, question. I have a friend that is going through a hard time, and she wants to file bankruptcy. Do you have like any documents where an individual could do their bankruptcy? She wants to do a bankruptcy, but she wants to keep her house because she's not working right now. So do you have documents on your website that would help guide, like for the paperwork that you need to file bankruptcy for?
Yeah, I've done a bankruptcy case a while back, and it was pretty simple. There's not a lot to it. And if they shouldn't be able to take the house from you living in, goodness, what's that called? The Homestead Act. Okay, anytime someone buys a home, unless the lawyer is brain dead, it is part of the process to make sure that your house is listed under the Homestead Act. And that prevents anyone from taking your home, even in a bankruptcy. If you have two homes, you can only do that to the home you're living in. So they could take the second home away from you.
No, she only has one home, but she's wanting to get rid of the car because she can't afford the car payment. So she's wanting to surrender the car and bankruptcy all her credit card stuff because she's been trying.
Well, again, I'll see what I can. I'll see. Let me make a note here. I'll see what I can find.
Like some way that you can show me, like how to access the forms online, or is this something you have to email me?
Well, we'll put it online if I can find something that I can put up that's pretty simple that I don't have to get involved in writing and creating and doing because I don't have time for it right now. But I know when I did a case a while back, and I just read through the process, and it was very, very easy. The key thing to a bankruptcy is basically making sure you list everyone you owe money to. And you also have to list your assets. You have to list both of those things. It has to be complete. You can't screw around with that. If you forget someone and don't get them in, and you file the bankruptcy and it gets approved and their name isn't on it, they're going to come out after you and they're going to win. So you have to make sure you get everybody. That's number one. So if they're pretty much broke and the only thing they have is a home and the income is minimum, they're not going to take income as long as it's minimum and basic sweat and tears, working.
Right.
Then it goes through, and basically once and you have to notify every one of these people that you're filing bankruptcy. But it's very simple. It's really just filling out the forms, and then there's a form to be filled out that you send out to these individuals that are that you owe a debt to, and they can come up and make their argument, but if there's no meat on those bones, they ain't getting nothing anyway. It doesn't matter. And they can't take the house as long as it's under the Homestead Act. And I can't believe that anybody bought a home and went through the whole process getting a mortgage and didn't register the Homestead Act in the county. That's a lawyer's thing. Whatever lawyer
she doesn't have the money to hire an attorney, so she's wanting
I'm not saying
an attorney. Like I'm not a fan of them. On top of it,
you don't need a lawyer for a bankruptcy as long as you just fill the forms out. You don't need to have a lawyer, okay? I helped somebody to do this. They didn't need no lawyer. But the thing is that, and it went through very smoothly. There was only one person showed up and made a big argument, and judge took all that information, at hand, and at the end of the day, he didn't say his decision in the court, but at the end of the day, they didn't get nothing because there was nothing to be gotten. There's no meat left on the bones. Now, the house is safe as long as the Homestead Act has been applied to it when the mortgage was originally created, when the sales went through. Any lawyer should have done that. And any lawyer who hasn't done that If that house is in jeopardy because that did not happen, I'd go after the lawyer who did the closing because they're in jeopardy for that. They're at risk.
Right.
To them, for incompetency.
Do you think her court, like bankruptcy court in her county, would have the paperwork that she needs to file the bankruptcy, or is she going to have to get these forms online?
Well, the bankruptcy court, I believe, if I remember, is federal. Yeah, you get everything online. Like I said, I will hunt around a little bit for it, see what I can put together, and I'll throw it up on the website. When I do that, I'll make an announcement on the Monday night that it's up there.
I
I don't
appreciate
know
it.
when I'll be able to get to it, but I'll try to get to it soon.
Yeah, totally appreciate it because she's buried over her head and she's just,
It's
trying
very
to make ends meet.
I'll tell you something that's going to surprise people. It's as simple as filing a divorce. All the money people give to lawyers is unbelievable. It's just forms. That's all it is. Forms and
Well,
affidavits.
my divorce cost me $75,000 back in 2006.
I
It
rest
was
my case.
painful.
I rest my case. It's ridiculous. It's a con job. The whole thing is a joke. Because again, all you have to do is go down to the court and get the packet, okay, a pro se packet, and that packet, it's just forms. That's all it is. And you fill out these forms. I did this for my niece, and I'm working with someone right now. I'm helping someone else out with the same thing, and it's just filling out all the forms. And then when they call for the forms, you give it in with whatever they ask for. And as you go along, there's an affidavit that needs to be filled out, an agreement, that goes the next step. It's just a bunch of steps of forms. That's all it is to it. Now, it is true, there are some points of argument, maybe 1 or 2 points of argument sometimes. Sometimes there's no argument because everything is just automatic. There's a formula for money.
I think now they do the meeting with the creditors online through Zoom.
It doesn't matter what they do. They don't look at. They either show up to the court or they don't.
They traditionally don't show up, to be honest with you, from what I've observed.
That's right. On a bankruptcy, the bankruptcy I did for somebody, goodness, it must have been about 30 or 40 individuals who were contacted as debtors that debt was owed to, and only one person showed up at the hearing. They only had one hearing. That was it. Go to the court. When you file all the papers, you come in for one hearing. Anybody that has a beef about it comes to that hearing. They make their point at the hearing. Maybe they file a paper, and that's it. There's nothing for anyone to argue about because all the paperwork, the forms, everything was there. The assets that they have, the debts that they have, what they own. So they don't take the car. They don't take the house. And if there's nothing else, no meat on the bones, and they don't get nothing, and that's it. End of subject. They can never bother you again. If they do, it's a violation of law, and you can sue them.
Excellent. Hey, I just want to give you an update because I talked to you probably about 2 weeks ago about my son, who I have conservator over, and how the public defenders try to talk him into getting rid of the conservatorship. So I finally have a court date. It's August 1st. So between now and August 1st, that sheet of paper that you posted online, I'm going to memorize that whole thing because last year the public defender screamed at me telling me that I needed to have an attorney, and I told her no, I don't. So I'm going to memorize that thing you put up on the computer so that I can just be ready to fire back at her.
Look, there's a federal statute that's called the next friend. You can come and represent yourself, and you can represent others. You can't prevent people. You see, the thing is you're going into civil law courts, and when you're dealing with those kind of courts, that's their club, and you got to be a member of the bar. That's what they call a license, which is no license at all, in order to operate in that. But that all is fraud, and it doesn't really hold up when you're headed up line. So I wouldn't worry about it. In other words, the appellate courts usually don't. Definitely the Supreme Court wouldn't hold it up, but the appellate courts usually don't hold that up. They permit pro se. Matter of fact, they permit pro se so much that all courts have to have a place, an office for pro se office to answer questions and assist to some degree with forms and different things that they might ask. The federal courts have them, the state courts have them.
Does that include for like a parent that doesn't want to get an attorney against one of their children that, like, I have another friend where her son got in trouble vandalizing like the association building where they live at, and she doesn't want to get a bar card holder, but the courts told her she has no choice but to get one because her son is 14, and they said that she has to have a bar card holder.
It's all baloney. Look, lawyers are true believers. You got to understand that. They believe what they were taught in school. This is what school teaches them, okay? They're true believers. Okay, but the bottom line, you can win in court just on using a federal statute concerning the next friend. That in itself is enough. There's Supreme Court rulings on that. Okay, and you can, and again, look at if you can't go into court to represent, take care of your own business or take care of the business of your children or even just anybody that wants you to help them. Okay, if you can't do that, then why do they have a pro se office to assist people that are running pro se cases? So, I mean, that in itself is a contradiction to itself. But with that, I got to move on because it's...
Okay, thank you, John.
Yeah.
All right, thank you.
John, it's after 11, 10 after 11 already.
Yeah, we're going to have to close down, and we'll pick up. I know there's a couple people came in late here into the queue, but we got to move on. So it's 10 after. Try to get into the queue early next week, and we'll take your questions or comments. With that, we're going to close down for the night. Good night, everybody. Thanks for coming, and hopefully we're going to get the work done that we need to get done. Good night.